In this bulletin, the full bench of the US federal court is set to decide on the future of patent rights on sold cartridges. Hello, I'm David Gibbons and here is the news. The three Federal Circuit judges reviewing the appeal in the Lexmark versus Impression Products case have ruled the full bench needs to decide the outcome of the case. Both Lexmark International and cartridge remanufacturer Impression Products have been presenting oral arguments to the Court of Appeal in Washington, D.C. since March 6. The case involves what happens to patent rights of printer cartridges sold outside of the United States, and also restrictions on cartridges sold to consumers, stopping them from being remanufactured, also known as pre-baked cartridges, is also being fought. The patent attorney defending remanufacturer Impression Products says he is delighted with this latest decision handed down in Washington, D.C. Even though both parties have to file again for the full bench hearing, Ed O'Connor sees it as an important strategic step forward for the aftermarket printing consumables industry. And Ed O'Connor joins me online now. Greetings, Mr. O'Connor. So what were the actual orders given by the Federal Circuit for the Court of Appeals in Washington, D.C.?
Okay, first of all, just so you understand procedurally, the original case was decided in Cincinnati in district court. And in that court decided that jazz photo was still the law, but that the Mallinckrodt decision, which allowed the prebate program, was no longer the law. So we won on the prebate, and Lexmark won on jazz photo. We both appealed. And in order for us to prevail, we had to overturn two decisions of the Federal Circuit, jazz photo and Mallinckrodt. And in order for us to prevail, the court would have to actually overturn its own cases. And a lot of people said, well, that's impossible. In fact, in oral argument, I basically told the court we were asking for the impossible, which is for them to overturn themselves, not once, but twice. The way you do that in Federal Circuit, the only way you, as a practical matter, you can do that is to have what's called an en banc hearing. En banc is Latin, which means before the bench. The bench means all the judges in that court. So if you understand it, there's a whole bunch of judges, and I don't know how many total. I think it's in excess of 11. I think it may be closer to 20. Every judge on that court will now sit on a panel, and then they will pepper the unfortunate lawyer, which would be me, with all kinds of questions. And they will decide whether or not to overturn either jazz photo or Mallinckrodt or both. So it's a big deal, and it very seldom happens. Yes. 0.1% of all Federal Circuit cases are decided by that en banc procedure.
So, Ed, what do you think is the significance of the full bench being involved in this decision?
Well, the first place is it's really the only practical way to overturn jazz photo and Mallinckrodt, which means the court having agreed to this procedure, and they don't have to do it, they did it on their own, means they're very seriously considering, and I believe it's not for sure, nothing is for sure, but I think it's a strong indication that they will overturn both of those cases. Otherwise, they would have just affirmed the previous decisions. So they said, we're not just affirming the previous decisions, we're going to turn this over to the full court to decide. If the full court, it doesn't have to be unanimous, but if a majority of the full court agrees with us, let's just take jazz photo. Yeah. They agree with us on jazz photo. There's another court you keep forgetting, the United States Supreme Court. So whoever loses or wins could then ask the United States Supreme Court to take this case. I would expect the Supreme Court would not take this case because I think we will win. And if we win, that's binding on all of the courts in this country, because the Federal Circuit, unlike other circuit courts, its decision is binding on all patent matters. So if we win here, that's the end of it for the entire country.
So will the outcome of this case have a significant impact upon the first sale of all products? I mean, not just printer cartridges, it could impact other industries as well.
Oh, absolutely. Both of these cases will. The first case, the Jazz Photo, affects any country, any company that imports products that are first sold overseas and brings them into this country for refurbishing and reselling. They don't even have to be refurbished. Just bring them in here for even for personal use. All are impacted by Jazz Photo, which is, in my opinion, a ridiculous decision. Once that's overturned, assuming it is, that means you can buy something overseas and bring it into the United States and use it or sell it or whatever you want to without fear of being sued for patent infringement. So that's a huge significance. The other one is possibly even broader significance because it doesn't have anything to do with sales overseas. It has to do with the ability to restrict the use by a purchaser of a patented product. That's Malandrot, which in Malandrot was the basis upon which the prebate program was previously upheld in other courts. If Malandrot is overturned, then that's gone as well. So both of these cases were, in my opinion, inappropriate restrictions on the use people can make of their products.
Now, you're fighting on behalf of just one cartridge remanufacturer in the US, and yet the outcome of all this is going to impact every remanufacturer's business in the United States.
Every one of them. And this little company, I've got to give them real credit for having the courage to be the only one in that whole case to stand up for Lexmark. And of course, their lawyer deserves some credit too. But the two of us have taken on, basically the giants in the industry, and we're not done yet. And the other thing is, on this en banc procedure, the Justice Department has been asked to get involved, and they probably will. The American Intellectual Property Lawyers Association has been asked to get involved. They probably will. The Patent Owners Association, Intellectual Property Owners Group, has been asked to intervene. They probably will. And so, there could be, all by intervening, meaning they'll file friend of the court briefs. So this could have a lot of people involved at the end of the day.
Ed, you've agreed to meet with the industry on May 14 in Las Vegas at the RT Imaging Summit to brief the industry further about this case.
Of course. And we've been ordered to rebrief this case, and our briefs are not due until the end of May. So when I speak in Vegas, we will not even have filed our new briefs yet. So the process will not be any further along than it is right now. But, I'll be happy to answer any questions and discuss this in depth with anyone who has questions about it. And everybody should, because this will impact this entire industry and many other industries as well.
Yeah, I agree. Thanks, Ed O'Connor. And for tickets to attend the RT Imaging Summit so you can be part of the full briefing, please go online to www.irecyclingtimes.com. And for other industry legal developments, go to this month's Recycling Times magazine with Kodak's Dan Burmeister on the front cover. See you soon with more breaking news. I'm David Gibbons.